Good morning, good afternoon, good evening from Singapore. So welcome back to week 10. So today we have Professor Larissa Vanden Herik as our guest lecturer. So continuing from yesterday on international criminal law by Professor Williams, we have Professor Vanden Herik, who is the Professor of International Law at the Grotius Center of International Legal Studies at Leiden University. She is the Vice Dean and Director of Research of Leiden Law School. She's also the Vice Chair of the Dutch Advisory Committee on Issues of Public International Law. And we'll hear today about those advisory opinions that she was a chair in. And this session will be moderated by our Professor Telish, who is dialing in from New York once again. And I'll leave the floor to her to say a few words.
Thank you very much, Violet. I just wanted to welcome Professor Vanden Herik, dear Larissa, on behalf of Nilofer and myself, and on behalf of the CIL eAcademy. We are so happy to have you with us today to talk to the participants of the Academy a lot, I think, from your own experience in dealing with crimes against humanity and genocide and the work that you do in the advisory committee in the Netherlands. So we are very much looking forward to your presentation. And as usual, and as our participants know, there'll be time for Q&A at the end. I will moderate that part, and then feel free to send your questions through the chat, or you know that we like it very much when you turn on the camera and the mic and ask a live question. So Larissa, the virtual floor is all yours, and we look forward to your presentation, and thanks again for being with us.
Thank you, Professor Taylors, dear Patricia and Nilofer, who is not here, but virtually in a way. It's a great pleasure for me to be here. I have the Leiden Law faculty behind me. But I thought I would speak in particular also on the advices that we have issued as in our advisory committee. And I thought that might be interesting for you. So I will share the screen. Yes, so there are two advisory opinions, one on genocide and one on crimes against humanity, that I would like to share with you. And it will take half an hour or so, and then we can have discussion. So the outline of the lecture is that I would first like to introduce this advisory committee that we have in the Netherlands. I think it's quite particular to the Dutch consensual culture, legal culture that we have, but I do think it is still quite interesting also for other jurisdictions. So I thought it would be interesting for you to hear a bit further on this advisory committee. And then I would like to zoom in on two advices that we have issued quite recently. One is related to genocide and the other to crimes against humanity, but they deal with quite different issues. So the first one on genocide, it is an advice on the use of the term genocide by politicians, and in particular parliamentarian declarations, and the question what the legal value is of such declarations. And then the other advice that I would like to discuss is an advice on the ILC draft articles on crimes against humanity. And of course, that's very pertinent today as the Sixth Committee is discussing on these draft articles, and the question to what extent we move forward to negotiating a convention. So first, I thought I would share with you a little bit on this Dutch Advisory Committee on Public International Law. So I also have the link here. And this Dutch Advisory Committee that I currently chair is a formal body, actually, in the Dutch legal system. It's established by law, and it's a committee that's composed of academic and practitioners, and we advise the government as a whole, but in particular the Minister of Foreign Affairs and the Ministry of Defense. And so we issue advice upon request of the government. It can also be upon request of the parliament, and we have the power to issue advice proprio motu, so on our own motion. And the interesting part is that once we issue an advice, there is an obligation for the government to share its position on the advice and on our recommendations with Parliament. So we are an independent committee composed by independent members, in particular academics, but we have this opportunity in a way to really invite and encourage our government to articulate positions and in particular legal positions on relevant issues of international law. So some of the subjects that we have given advice on recently, a main part of our work, and this of course is particularly interesting, I think also to Professor Teles and Nullifer Ola, is that we comment on the work of the ILC. So, of course, during when the ILC is preparing reports and articles, they always invite governments to comment on their work, and the Dutch government then invites us to assist it in that. So we have advices on the work of the ILC on peremptory norms, protection of environment in relation to armed conflict, protection of the atmosphere, provision application of treaties, so all the work of the ILC, in fact. And what the Dutch government does is that they send in their position on the work of the ILC, but they always annex our advice, so our full advice actually, even if they don't fully agree with it. But I think this is a very transparent way of doing things, and I think actually it renders the input of the Dutch as a whole to the work of the ILC very, very strong. So the Dutch government will always comment actually on the work of the ILC. And in that way, I think it's quite a good example. It's quite a model, I think, also for other states to look at, to make sure that there is this consistent input on the work of the ILC. Well, we do not only comment on the work of the ILC, we also issue advice on other topics that come up. For instance, we have issued advice on the use of drones, humanitarian assistance. And sometimes we advise together with the Council of International Affairs, which is not only on international law, but broader, and that's generally composed of former ministers, diplomats, and for instance, we have there issued advices on cyber warfare, autonomous weapons. And we also advise at the request of the Parliament specifically. So, for instance, on the question of whether there is or should be a right to denounce nationality, but also the question of non-lethal assistance to armed opposition groups, which is, of course, a question that came up in relation to the practice of the Dutch and also other Western states to support armed opposition groups in Syria. So, a very sensitive issue. We do not issue so many advice on our own motion because of the very political nature of many of these questions. So generally, we advise at the request of government of Parliament. So this was just a short introduction, and then I would like to zero in on two advices that I think are particularly interesting for you as they relate to international criminal law. So first, there's an advice on the use of the term genocide by politicians. So the full name is Advisory Report on the Scope for and Significance and Desirability of the Use of the Term Genocide by Politicians. And it's an advice that we issued in 2017. And this was actually also requested by Parliament against the backdrop of atrocities that were committed at the time by the Islamic State against the Yazidis and other groups. At that time, the European Parliament, the Parliamentary Council of the Council of Europe, the US House of Representatives, they had all characterized those acts that were committed against the Yazidi as crimes against humanity and genocide. And also the UK House of Commons had been very early in its finding that this violence against Christians and other minorities in Syria and in Iraq, they said clearly falls within the scope of genocide. So in this context of national and international condemnation, the Dutch Parliament also invited the Dutch government to take a position and to make a finding that genocide was being committed by the Islamic State. But the Dutch government was actually very reserved, and it held the position that only courts can make legal determination on what constitutes genocide. So then there was a discussion between Parliament and the government, and the question was referred to us as the advisory committee. To what extent politicians, so the government, parliamentarians, can use this term genocide and make determinations. Well, in our report, we made a distinction between past ongoing atrocities and whether they should be qualified as genocide. The legal issue at stake is very much also the question of prevention. So in our advice, we focused in particular on ongoing atrocities and the question to what extent entities other than courts can use the genocide label for this. Well, in our findings, we said, and I'll go through them very quickly and then we can discuss later together. But what we said is that this idea that only courts can make a determination on a genocide needs to be qualified. And actually we said that in fact, as the chief representative of the state, the government bears primary responsibility for making determinations on violations of the law, including determinations that genocide is being committed. So we did not agree with the statement of the minister in this regard. Then we say, in addition to the government making these kinds of determinations, it is of course also possible that a parliament adopts an autonomous position, in particular if a government is reserved in doing so. But we also said that parliamentarian positions and declarations do not have special significance in international law. So there is a difference in legal value between a government declaration and a parliamentarian declaration. So we said, in principle, both government and parliament can also make these declarations that genocide is being committed in addition to courts. We also advised restraint. We said that these kinds of determinations have to be applied to facts. So there must be a thorough investigations of facts beforehand. And if there are no sufficient or reliable facts, then restraint is to be preferred. And we also said that given the Netherlands' commitment to the international legal order, the preferred course of action would also always be to support international determinations, for instance, in particular by commissions of inquiry. But of course, if these are not forthcoming, that's not an impediment to make a national determination. So then we said these kinds of determinations by governments are actually also important because they may trigger the obligation to prevent. And we are aware, of course, that the question of what the substance of this obligation to prevent is, so what are third states expected to do, is still open. So the precise substance is not detailed in the Genocide Convention, for instance. The obligation to prevent crimes against humanity currently only exists under customary international law. But of course, governments and also parliaments, by making statements and by clarifying what they think that the substance of the obligation to prevent is, they may gradually clarify the law on this matter. So it's very important to actually engage in a discourse on the obligation to prevent. So what we also said, and I think that's a very important part of the advice, is that in this prevention phase, what we very often see is that there is an emphasis on genocide, and there will always be this question whether certain atrocities can be characterized as genocide or not. And we said, well, in fact, if you are in the prevention stage, we would advise to use the two terms of genocide and crimes against humanity always together at this prevention phase. It doesn't really matter what the precise terminology is. This is very important in a criminal law context when you are prosecuting individuals. But in the preventive stage, the most relevant question, of course, is what the preventive acts are. And the obligation to prevent, we argued, is the same for both genocide and crimes against humanity. But what we did say, and that's then recommendation 10, is that we advised the Dutch government to support the efforts of the International Law Commission with respect to drafting a separate convention on crimes against humanity, and also there to specify what the obligation to prevent particularly entails. So this is in a really a nutshell our advice, and I'll go to the second advice now, and just to make sure that we have sufficient time to discuss it in the Q&A later. So the second advice is an advice specifically on crimes against humanity, and so this was very much in the context of the Dutch government inviting us to comment on the work of the ILC, which had been working on crimes against humanity with Professor Sean Murphy as a special rapporteur. And then the Dutch minister explicitly invited us also to discuss the relationship between the ILC articles and what we call the Mla Initiative. And I'll explain this in a minute. So the advice was issued in 2018, and as said, it commented on the work that was started in the ILC in 2014 with Special Rapporteur Sean Murphy, who and the ILC really decided to start this convention because, and maybe you have discussed this yesterday, in international criminal law, we have this independent convention for genocide. We have a convention for war crimes, the Geneva Conventions, but of course, a global convention on crimes against humanity was the missing piece. There's no specialized convention. So there was a gap on that. Now, the Mla Initiative is another initiative that somehow is being developed in parallel to the initiative on crimes against humanity. And you have a link here. Interestingly, around the same time that the ILC decided to include this project for new crimes against humanity convention in its agenda, there was also another initiative. So in 2011, there was an expert meeting in The Hague. It was actually held outside the structures of any international organization. It was a meeting organized by Belgium, the Netherlands, and Slovenia, where representatives of ministries of justice, foreign affairs, of 19 different states came together. And they also found a legal gap, just like the ILC in a way, a legal gap in the international legal framework on international criminal justice. And the gap was a little bit different, because the gap that was found in The Hague at that time was mainly about the fact that there was no full and well-developed international legal framework on mutual legal assistance and extradition for the adjudication of all international crimes. So it was said that, of course, there is a genocide convention, but actually the provisions on mutual legal assistance and extradition that we find in this genocide convention that was adopted in 1948, they're actually not modern enough to deal with present day questions of extradition and mutual legal assistance. And also the provisions that we find in the Geneva Conventions are perhaps outdated. So the proposal that underlies the Mla Initiative, the Mutual Legal Assistance Initiative, is a proposal for a modern procedural multilateral treaty on mutual legal assistance for all the international crimes. So not only crimes against humanity, but also genocide and war crimes. And ultimately, there are 6 states that lead this initiative, which are Argentina, Belgium, Mongolia, the Netherlands, Senegal, and Slovenia. So the question is, okay, but how should we understand the relationship between the draft articles for crimes against humanity on the one hand, and the Mla Initiative on the other hand? Are these two competing initiatives, or are they actually mutually reinforcing and complementary? And that was one of the questions that the Dutch minister asked to us when he asked for this advice. So again, I'll briefly summarize our findings and recommendations, and then we can discuss them together. So firstly, what we said as an advisory committee, we said, of course, that a specialized convention on crimes against humanity would be very welcome, and it would complement indeed the treaty regimes that we do have for the other two core crimes of genocide and war crimes. And we also said that it's very important to have an independent convention on crimes against humanity because they codify existing rules on customary international law, such as the obligation to prevent that we just discussed already. But they also serve a gap-filling purpose more widely. For instance, because a new treaty could provide a dispute settlement clause and a basis for jurisdiction of the International Court of Justice. And that might reduce this over-focus on genocide that we have. So all the cases that come before the International Court of Justice that deal with atrocity are always framed, must be framed in terms of genocide, because there is no legal basis for the ICJ to discuss crimes against humanity issues. So there is really a gap there. And thirdly, we welcomed this new idea for a Crimes Against Humanity Convention because the draft articles, as they are proposed by the ILC, they also offer a very robust legal regime for state cooperation, so for mutual legal assistance, specifically for crimes against humanity. Then on this question, how the ILC draft articles on crimes against humanity relate to the ICC, for instance. So we, of course, the argument can be made that since there is already an ICC statute, we have a definition of crimes against humanity, why would there be a need for an independent convention? We very much see the draft articles of the ILC and the ICC statute as complementary, as a mutually beneficial relationship. And the draft articles, in a way, offer support structure for the ICC, corresponding with the idea that the ICC is based on complementarity. So the fact that states increase the cooperation on a horizontal level allows them to better implement the idea of complementarity that underlies the ICC. And I think it's important to emphasize that even states that are ambivalent towards the ICC or that are not party to the ICC have an independent interest in these conventions on crimes against humanity, or even also the Mutual Legal Assistance Convention, because of course this idea that there is a duty to prosecute international crimes, that is an international legal obligation that predates the International Criminal Court and that exists independently of the International Criminal Court. Now, in our advice, we said that even if there are perhaps inadequacies in the definition of the crimes against humanity definition of the Rome Statute, we advised actually the Dutch government and so also the ILC not to deviate from that definition because of the importance of legal certainty. So if we have all these varying definitions of crimes against humanity, that may have a very serious fragmenting effect. So we advise to adhere to the definition. In the end, I think that was maybe rather a conservative position, and what we see is that the ILC, the rapporteur and the ILC as such, they adhere to the definition except for the definition of gender. So there's the definition of gender in Article 7, paragraph 3 of the Rome Statute, which offers a very conservative approach towards gender, equating gender actually to the two sexes of male and female, so more in a biological sense, whereas the special rapporteur also noted that the discussion on gender has advanced and much more understanding gender as a social construct. And so that definition of Article 7.3 of the Rome Statute was not replicated in the ILC proposed articles, which I think is a very wise decision. we also indicated, and that's perhaps most importantly, specifically in relation to the question of the minister, we said the fact that we have those two initiatives coexisting, so on the one hand, the draft articles on crimes against humanity, and on the other hand, the MLA treaty, that is not problematic at all. Those two initiatives are mutually supportive. They do not compete. And even if they were both to materialize and turn into treaties, which for both is a question mark still at this moment, but not all states may sign up and ratify both. So we know that international law develops organically much more than systematically, and so both these initiatives that have this very important gap-filling function are important stepping stones in this project of international criminal justice. And what we see is that states like the Dutch government, also the Slovenian government that were behind the MLA treaty, at the very beginning, they were more reserved towards the crimes against humanity project at the ILC, but over time, they have also taken this position that indeed the two initiatives coexist and they are mutually supportive. So all the states that are behind the MLA treaty are really also supporters of the crimes against humanity project of the ILC. And of course, there's a certain overlap between the two where they both deal with mutual legal assistance for crimes against humanity. But the MLA treaty is very important in addition to that, because it offers independent provisions on mutual legal assistance for the crime of genocide and for war crimes. So they really update the Genocide Convention and the Geneva Conventions. And in turn, the Crimes Against Humanity Convention is very important because it offers something that the MLA Treaty does not offer. And that is particularly related to the obligation to prevent crimes against humanity, which is, of course, paramount in a way. And in addition, it offers these dispute settlement clauses that relate to interstate adjudication, for instance, at the International Court of Justice. So that really serves to reduce the overemphasis and the overfocus on genocide that we have now because of this gap in relation to crimes against humanity. The Special Rapporteur, I must say, in one of his last reports was more concerned about what he saw as a competition between the articles on crimes against humanity on the one hand and the MLA treaty on the other hand. And he indicated, for instance, that states, if some states sign up to a Crimes Against Humanity Convention and others to an MLA treaty, there is no mutual legal assistance regime between those states. So they are not bound and they cannot cooperate between them because they're bound to different regimes. I think that's a concern. I think we should not overstate that concern. It can also be that if both these initiatives materialize and states signing up for the Crimes Against Humanity Convention, they will then put implementing legislation in place. And in a way, the fact that they already have implementing legislation on mutual legal assistance for crimes against humanity, that might also make it easier for those states to become a party to the MLA treaty, because they will already have the implementing legislation in place. Moreover, I think it's, as I already said, the fact that that both treaties, they overlap a little bit, but they also have, both of them, their own unique elements that the other does not have. So that is why I would think there's really an argument to be made that both initiatives need to be pushed forward to complement actually the and to fill the gaps that we currently have. And lastly, I think what's important to emphasize is that when we talk about mutual legal assistance, this is an area of law that is inherently, let's say, a patchwork. So if we talk about extradition, if we talk about mutual legal assistance, if you want to cooperate as one state with another state, you always will need to find, is there a bilateral treaty? Is there a multilateral treaty that allows for cooperation? So this patchwork nature is somehow inherent in this area of mutual legal assistance. The MLA Treaty, for instance, recognizes what I call the patchwork nature. So the draft as it is on the table right now is a draft that envisages mutual legal assistance provisions in relation to crimes against humanity, genocide and war crimes, but it already includes an optional extension. So states may sign up for this treaty and then extend it to aggression, torture and enforced disappearance. So, but states may also not sign up or sign up only for enforced disappearance and not aggression. So inherently, there will always be some kind of patchwork element in this. Lastly, to return to our advice, what we said here again, as in our previous advice, we said that in relation to prevention, it's very important to underscore that the obligation to prevent genocide and crimes against humanity, those two obligations should be seen as twin provisions in terms of content and in terms of scope. And so what we also said is that what the ICJ said in its 2007 genocide judgments on the obligation to prevent genocide should apply in a similar way to the obligation to prevent crimes against humanity. Well, lastly, in our advice, we also said that it would be important to include a monitoring mechanism in the Convention Against Humanity. We also said that there might be merit in thinking about how to apply non-statutory limitations and whether those should also apply in tort proceedings in addition to criminal proceedings. Those two recommendations were not taken on board by the ILC. So the special rapporteur had a position which I think is very understandable, that the Crimes Against Humanity Convention should be kept as lean as possible. So also issues in relation to immunities, and I already understood that you discussed this yesterday, discussions in relation to amnesty, they were all kept out of the proposed ILC articles. Because of course, those are very divisive issues, they're very contentious issues. So the idea was to keep the Crimes Against Humanity Convention, the proposed articles, as lean as possible, really to enlarge the chances of this convention coming into being. Well, as said, it is now being discussed. So Professor Taylor may have the latest for us from New York on this. It is not a given at all that either of the two conventions that or the proposals actually, that I just discussed will come into being. I do think that we have a shared interest in trying to put them forward. I really think that they fill a gap that is out there, very important gap. But I look very much forward to discussing this now together with you and to hearing your views on this. So thank you.
Thank you so much, Larissa, for this very interesting presentation. I think the first thing that I want to highlight is how interesting it is. I mean, I know about it, and I'm fully aware of the great work that has been done over time by the Dutch Advisory Committee on Public International Law, but perhaps it's not so well known to the participants that we have in the Academy, which are from all over the world. And it's really a good model. I think it's really a good model to have an independent advice that the government or the parliament or even Popul Moto can be given on important questions that are certainly legal questions, but they are in many instances, as you mentioned, in sensitive issues and of course against a political background. And it's very interesting to see these two advices that you mentioned that are extremely relevant to the subject of our weekly topic on international criminal law and international humanitarian law, on genocide on one hand and on crimes against humanity on the other, but they're very different in nature. I mean, it's quite striking that the first opinion is the first advice is much more I would say, the political issue on how to use genocide and the impact that the use by politicians of the term, which is a clear legal term, but sometimes is used in a political context. And then the second advice, which of course for me, having been already a member of the commission while we finished the work on crimes against humanity, is something that I knew, of course, but also, of course, much more technical, much more legal. But that really shows, I think, probably something that Professor Williams has highlighted also yesterday and probably tomorrow in our lectures, that the edifice of international criminal law and IHL are not yet, fully complete, and how the Crimes Against Humanity convention, a possible future convention, would be a great step towards the completion of that that edifice, legal edifice, where certainly the Rome Statute that is at the center, but for the horizontal, the cooperation at national level, a Convention on Crimes Against Humanity, and I agree with you, complemented also with the Mutual Legal Assistance Treaty that has the advantage to cover the three crimes. That would be a very interesting development. I have to confess that I'm not fully following the negotiations in the Sixth Committee, but of course, because I'm in New York, I've been hearing about it, and there seems to be some advances. It's always slow. It's something that we've seen not only on this topic, but when the ILC finishes a draft convention, like in this case, before the time that the Sixth Committee takes action. It's not always immediate, but there seems to be a good move towards the possibility of having some intercessional work, and possibly sometime in the near future, it's hard to say when, but sometime in the near future, of having a diplomatic conference for negotiation of a Convention on Crimes Against Humanity, which of course could be very much and will be very much based, if it happens, on the work of the Commission, but might want to think some of the questions that you rightly mentioned that were left out, like the issue of the monitoring mechanism. That was one of the issues that was left out, or which is, I think it's more practical. I think it's more the issue of whether there's by now a certain fatigue of monitoring mechanisms, also with all the human rights systems, the treaty bodies, and all the reporting duties. But then also more sensitive issues like the question of amnesties or immunities. And I just wanted to give some reflections also from my part, while maybe our dear participants are warming up to questions. Please don't hesitate. We have enough time. Professor van den Herik was very good in keeping to a short presentation so that we can have more time for questions. So please feel free to raise your hand to ask a live question, or to put a question on the chat that you might want to ask also. So how coming back to the question of the use of term of genocide by politicians. This, you said that this advice was based on the question of the Islamic State and the Yazidis. Do you think this question would come up again also in other cases, or would the advice? I'm just trying to think also how the advices that the committee gives are then taken up perhaps in similar cases that were not the ones that motivated necessarily the request for the advice. If that issue would come up in relation to a different instance, because unfortunately these are situations that occur from time to time. Would there be another request, or would you the same advice would be also used? Let me just ask you that question to see in the meantime, the participants might have a question or two.
Yes, I think it's a very interesting question. In particular, in principle, of course, we are an advisory committee. So we always insist on the fact that we give general advice, and we are not a commission of inquiry, or so we do not apply the law to the facts, so to say. So for instance, in this advice, we were also asked, do the atrocities that are being committed, do they amount to genocide? And we said we are not taking a position on this because we do not investigate the facts. So we only give a general advice. And for instance, also in relation to the question of non-lethal assistance to armed opposition groups, which is outside international criminal law, but it was a very sensitive issue in the Netherlands. And Parliament, of course, is very often inviting us to condemn certain acts by the government, but we refrain from that. So we only give general advice. Now, as you may know, the Dutch government, along with some other governments, in particular from Western states, has been active also in issuing declarations in relation to the situation of the Uyghur in China, and they also issued a declaration on that. So at some point there was a question whether they would ask for a separate advice on that situation. But then we indicated precisely this, that our advices are of a general nature and they do not relate to specific situations. So we do not apply the law to specific situations. And so we, in a preliminary phase, said that we did not think there was a need for separate advice on this.
Thank you. Now that makes it also, I mean, very interesting that the advice is given on a general and abstract basis and not tailored to the specific case, although it might be prompted by a specific case. So I think that also gives a more clear picture of the role and the important role of the advisory committee also because of that. I think that we have a question from Shehzadi who's raising the hand. So Shehzadi, please go ahead.
Good afternoon, Professor. I hope it's good afternoon there. For me, this lecture was a bit new, as Professor Patricia also mentioned that since we have been from different countries, we have heard this advisory committee and it's all governance structure and advisory recommendations for the first time. And I found it very impressive and a model to be followed by different countries, for instance, in my country as well. I have a question, two questions basically. One is related to the working of advisory committee, and the second one is a little bit more how we can take help or seek help from you. First one is that sometimes the governments have some political orientations and parliament is a bit different in ideological perspectives from the government. So if your advisory committee is also giving the advice, or the parliament is also focusing on government to use that term genocide or crimes against humanity, but the government is a bit reluctant to use that for its own political and other ideologies. So does that advisory committee has, I mean, power, not power in that particular sense, or does it has a kind of ability to question the government to answer the state or the people? Because government is always, as a representative government, it is always answerable to the people since being elected. So do you have to question them as well, apart from giving the advice?
Yes. No, thank you. I think so. I sort of saying a little bit on this advisory structure precisely because I thought it might be interesting also, you know, for you coming from different jurisdictions. And I think it's very much part of a Dutch legal culture and even social culture. You know, we have very much a culture of meetings and of finding consensus. And so this advisory culture that we have in the Netherlands, it's not only on international law, it's on all issues. All the ministries have their advisory, and it is a way of seeking, of building consensus and seeking support and reaching out to society in a way. I think for the government, there's also interest in these advisory structures, in the sense that, you know, when things become very difficult between government and parliament, they outsource it. So of course we are aware of that. So then when it becomes very difficult, they say, well, let's ask for an advice, and then at least you have some time, you know, so they buy time in a way. But I think still, from an international law perspective, you know, it is really because we have an opportunity to make sure that the conversation becomes more legal, and that there are these legal elements. So we really invite the government to take a position on certain issues and to take a legal position on certain issues. So of course, we cannot force the government to we can invite the government to take a position. Generally, they respond to it, but we cannot force the government to take a, let's say, a practical position in relation to a certain situation, unless there's a legal obligation in international law. But of course, there's no legal obligation to make, for instance, a determination on genocide. So that we can't do. We really. Yeah, we keep it as a legal advice. Then sometimes we give recommendations that go a bit beyond the legal, in the sense that we say we think that international law should develop in that way. But we are also very aware of our position. So we are not an activist body, we are an advisory body. And so, for instance, we do not offer so much advice on our own motion. So there are, for instance, issues on international law, on international criminal law, but also on international law more generally. I think, for instance, now the Netherlands, like many other Western states, we have these policies of nationality stripping of foreign fighters, which I think is very problematic from a international law perspective, from a human rights perspective, but also from an interstate perspective, because we take nationality from the dominant nationality, and you burden other states with a problem that's effectively yours. So I think it's a very big problem from a legal perspective, but we haven't issued an advice on our own motion yet, precisely because we don't want to politicize our own being, so to say. And we think we have other organs like Amnesty International or NGOs, civil society, that is their task. So we are quite conscious of that. And also, so Parliament, of course, they always invite us to issue advice on specific issues, and they want actually us to condemn certain situations. And there also we always say, no, we are not a fact-finding body, we are not a commission of inquiry, we only offer advice on general international law.
Professor, there's a question in the chat from Shamsu, that whether there is an issue of extradition as included in the new treaty, as we have seen most of the genocide criminals are taking refuge in another country. And how about punishment for genocide? Is there capital punishment or is it discouraged?
So, so in both the Crimes Against Humanity draft and in the MLA draft, of course, the extradition provisions are provisions that are included with the aim, with the limit to respect human rights. And so there are certain limits on extradition that states have. You can't, for instance, extradite if there is a real risk of torture. So there are these limits. Sorry. Oh. Well, that there are, and so the provisions on mutual legal assistance and on extraditions are limited, are circumscribed by human rights obligations that states have, and in particular European states have very strong obligations also in relation to death penalty. So that would be impossible for them.
And Professor, I have some questions as well. So the first question is, so you mentioned in the report that it suggested that there should be a full investigation of facts. Are there any case studies where there are states undertaking such independent fact-finding besides the UN having fact-finding? For example, the situation as you mentioned in Xinjiang, one of the issues is that they can't send a UN body there to investigate because of their refusal to cooperate. And my second issue is whether you see a tension in international criminal law. It's from a more theoretical point of view that there is this tension of pinning down individual responsibility when we're talking about a systematic policy perpetuated on a state level.
Yes, thank you. I think a very important question. So we, in our advice, we were very aware of the tension that I think you also allude to, and that if you have unilateral determinations of genocide, that in a way also undermines a multilateral international legal order. And the Netherlands, in its constitution even, there's an obligation for the government to contribute to an international legal order. And the more you go unilateral, so to say, the more you undermine this idea of a multilateral international legal order. So already for that reason, we have this explicit advice where we, in relation to the first question, I said we don't oblige the government to take, for instance, a position, but it is clear that we do advise the government on how to engage with international law, actually. So in particular, this report, it's true, it goes a bit beyond the legal technical law, and we advise the government on how to engage with the law. So we advised restraint, and we said it's always better not to go unilateral, in particular for, let's say, a middle-sized country or a small country like the Netherlands. We have an interest in an international legal order that is truly multilateral. And in addition to that, there is this question of fact-finding. So you should be reserved to make legal determinations when you have not done independent fact-finding. Of course, this is very complicated when a certain state doesn't offer access. But then, as an international community, we need to discuss on the question to what extent, preferably international bodies like UN Commission of Inquiry, can make inferences. Can you at some point make inferences? But it is, of course, really preferable to have those discussions at the international level and not to have separate regimes for unilateral determination, depending on the country and the eagerness of making certain determinations in a certain geopolitical setting. So then on the second question of course, on let's say individual criminal responsibility and state responsibility, or the different domains. And of course, let's say the genocide advice, you could say that was not really an advice that related to international criminal law in the strict sense. So international criminal law in the strict sense is about prosecuting individuals for international crimes, either by an international court or by a domestic court. But what we see, of course, is that these international crimes, they also have a separate, perhaps we can say, legal regime that relates to state responsibility. And then you have, again, separate legal questions that relate to the question of prevention. And of course, then from a legal position, the question is whether a genocide, and the definition of genocide that we have, is the same if you talk about genocide as an international crime with international criminal responsibility, or genocide if you talk about genocide as in relation to state responsibility, or genocide when we talk about prevention. And in particular, when we talk about prevention, there is a different legal regime in the sense that even if it's important that there are facts that are being established, you do not, of course, need to meet the same evidentiary threshold as you need to meet in an international criminal prosecution. So if we talk about prevention, generally the threshold that we have from the ICJ case in the Bosnia in 2007 judgment is that there should be a real risk. So you have an obligation to prevent as a third state if there is a real risk, a serious risk that genocide is ongoing. So we have the same crime, the same definition, but you have different legal regimes depending on the legal question: individual responsibility, state responsibility, or prevention.
Thank you very much, Larissa. There is a request for a live question from Ariane. Ariane, please.
Okay. Hello, hi, Professor Van. Thank you so much for that. Very insightful and sorry, very insightful discussion regarding genocide and crime against humanity. So my question is, due to the highly political nature of determination of crime against humanity or genocide, how can we ensure that the government or parliament can still have their sovereignty of this sovereignty of the state is not breached? For example, having the investigation of the international court in a state if it is obvious that there was a crime committed, or there was a crime committed. For example, in the case of Rohingya, or in the case of in Malaysia, like that, such cases.
Yes, thank you. I think this is a very important question. So then we talk about genocide and crimes against humanity and the question of state responsibility specifically. And so currently we have genocide that is governed by a treaty regime, the Genocide Convention, and crimes against humanity that's not governed by a treaty regime, but that doesn't mean that it's not ruled by international law. So crimes against humanity at present is governed more by customary international law. So I would argue that there is state responsibility for crimes against humanity under, you can make an argument under customary international law. There's an obligation to prevent crimes against humanity, even for third states under customary international law. But of course, we do have really a gap. And mainly the gap that we have is that it is impossible for states to bring, or close to impossible, to bring a case before the International Court of Justice in relation to crimes against humanity, because we do not have a convention that provides the International Court of Justice with jurisdiction. So in terms of state responsibility, there is really a gap, which is why there is this need for an independent convention on crimes against humanity. Then, of course, the next question will be whether states sign up to this convention, and to what extent they will then make reservations. But the fact that we need to push, I think, together for this convention to come into being will be the first step before we can actually even start to consider the next steps that are related to your very important question. So I think that your question really highlights once more the gap that we currently have in international law on this matter. Oh, you're
Sorry,
on mute.
Patricia, I think you're on mute.
Okay. Yeah, thank you so much.
Yes. Yes. So I was just saying that there's an additional question on the chat by Shamsul about what is your opinion when one state commits a genocide crime against another state, and how this is will be considered under the current legal regime. But I think you've just answered also. I mean, in terms, there's this issue, both the state possibility of the state responsibility or the possibility of individual criminal responsibility. And it's very interesting to point back historically to the war in the former Yugoslavia, where we had prosecution for individual crimes before the International Tribunal for former Yugoslavia. And then you had also the ICJ cases between Bosnia and Serbia and Croatia, which illustrates really this double dimension. But I don't know if you might want to add, we're reaching the hour. Maybe you want to add something else in response to this question, but I think you had already addressed it, but maybe one last comment from your side.
Yes, no, I think I always see international criminal justice as a web in a way. So we need these complementary mechanisms of individual responsibility and state responsibility, but also outside courts. I think it's very important to think outside courts and to really emphasize the very important role that Commission of Inquiry can play. And then that's maybe then my last remark, which is why I thought that it would be important to think about a monitoring mechanism for a Crimes Against Humanity Convention, maybe not so much per se to look at implementing legislation, because I see, of course, the monitoring fatigue and so on, but to think about this in a different way, to think about creating at least a, let's say, a space for states where they can discuss together in a joint sense what, for instance, the obligation to prevent should mean and should entail in certain situations. So, of course, international criminal law is always too late. Which is why the prevention obligations in relation to genocide and crimes against humanity are so important. And we know from the ICJ judgment that these are binding obligations, that even third states have an obligation to prevent ongoing atrocities in another state, depending on their capacity. But we don't still know what states are exactly supposed to do. And probably this cannot be written in stone, because it will depend on the situation. But now what we see is this unilateralism where states decide for themselves what they do. So you can impose sanctions or not, but sanctions are, of course, very problematic in themselves as well. And so I think it would be important to think about how to create a space that's not a court, but a space for states where they can come together to discuss obligations to prevent. And of course, ideally, this space is the Security Council, but or even a General Assembly. But maybe there is merit in creating a specialized space for these atrocity crimes, precisely because also we know that there are current stalemates at other levels. So I think, but in general, so in a way, this lecture was maybe a bit of a side trip to international criminal law. That is the area of this week. But of course, all these issues are very closely interlinked. And so in a way, I think it's important to always keep this broader panorama in mind when you zoom in on criminal prosecutions in The Hague or elsewhere.
Thank you so much. I think with that, this is the perfect ending. I fully agree with your idea of the international criminal justice being a web or a system, and we see all these parts of the same system. And I think it was very, very interesting to learn more about this very interesting institution that is the Dutch Advisory Committee on Public International Law, and how it has been also active in the areas of international criminal law with the advices that you explained to us on genocide and crimes against humanity. So again, on behalf of Nilofer, myself, of the Academy and all the participants, I'm very grateful, Larissa, for you having accepted to spend time with us today. And I also thank our dear participants for the great questions that they have asked. And we'll give you a virtual applause as some of you are already giving, and I see some nice words also coming in the chat. So thank you so much, Larissa. Thank you to all our participants. Tomorrow you will continue with Professor Williams, and then we'll have next week our continuation of the Academy for week 11. So we're reaching the last stretch of the Academy. So thank you so much, and have a great day wherever you are. Thank you.